Today, we have a special guest that may come as a surprise to many of our listeners and a shock to some. Our guest is widely considered to be the most successful medical malpractice defense lawyer in the state of Georgia. At one point in his career, our guest had a winning streak of 50 defense verdicts in a row. Our guest grew up in rural West Georgia along the Georgia Alabama border in the frontier town of Carrollton. He played football at Central Carrollton High School and excelled on his high school debate team. He consistently defeated the debate teams at all the fancy high end private schools in Atlanta and led his debate team to numerous statewide and national championships. He graduated from West Georgia and went on to the University of Georgia Law School. And from the beginning of his career, our guest has defended doctors and nurses accused of medical malpractice. He started his own defense firm back in 2005 with his wife, Molly, who was also his law partner and a highly accomplished lawyer in her own right. He is a member of the prestigious American Academy of Trial Lawyers and just recently received the Lifetime Achievement Award, the highest recognition given by the Chief Justice's Commission on Professionalism, for his pro bono work in the community. And lastly, and most importantly, our guest is the father of seven, yes, seven children, including one son who practices law with him, another son who is a lacrosse player at Princeton, and a cheerleading daughter at the University of Georgia, all high achievers like their father. I've tried many cases against this defense lawyer, sometimes coming out on top, sometimes coming in second. And I can tell you, he is the ultimate professional, a skilled courtroom opponent, a highly ethical lawyer who always fights hard for his clients. When a doctor or nurse gets sued in Georgia, our guest is almost always their defense lawyer of choice. So it is my pleasure to welcome to the show Mr. Paul Weathington. Paul, welcome to Face the Jury.
Lloyd, thanks for having me. And you read my bio that I wrote very nicely there. Uh, that was way too much. I appreciate it coming from you, a most worthy adversary in these cases. I appreciate all those nice comments.
Well, this is my pleasure, and I'm really happy to have you here on the show. And since I'm sure you are a regular listener to my podcast, Face the Jury, you know that this podcast is focused primarily on the issues of medical malpractice from the patient's point of view. So you are my first guest to bring the doctor's point of view, the nurse's point of view, being on the other side of medical malpractice cases. So I want you to tell us, first of all, how you came to focus your professional life on defending medical malpractice cases.
It's not that noteworthy of a story. I practiced big law here in Atlanta at Troutman Sanders and then with David Flint. I got recruited to go back home to Carrollton to the Tysinger firm out there that had a niche practice in medical malpractice defense in the West Georgia area. David Tysinger developed a bunch of great clients, the Houston Clinic and Tanner Medical Center and groups in that region. And I was lucky enough that he asked me to help him with cases, and I sort of stumbled into it. Tried my first case by myself with Lance Lurie as a co-defense lawyer before he saw the light and matriculated over to the plaintiff's side. But that's kind of how I ambled into it. And then I was lucky enough to be trying a murder case in Carrollton while Hunter Allen was trying a malpractice case the same week. I was in Superior Court. He was in state court. I gave him the lowdown on Carroll County juries and that kind of thing. And next thing you know, he talked me into coming back to Atlanta and putting silk stockings on again and working, doing a lot of Emory's defense. And I'm very honored to have David Tysinger and Hunter Allen as mentors. That's kind of how I got into MedMal. And honestly, I'm not a legal scholar. I was on the law review, and that's about the extent of it. But the law in medical malpractice cases is not as challenging sometimes as the medicine, as you know, in these complex medical issues. And every case is different. Every case is a tragedy on your side. And a blow to the ego on the doctor's side that he's being accused of malpractice. And so the facts of these cases are interesting. And I was never cut out to be a guy that reviewed contracts and that kind of thing. And nor were you. And each case presents its own nuances and challenges, and it's been a good niche to be in.
Well, Paul, let me ask, is it true that you had a winning streak of 50 defense verdicts in a row at one time?
Lloyd, I'm not sure. I didn't promulgate that urban legend. The Daily Report kind of liked that quote. Uh, in that 50, there might have been one or two where they gave them $25,000 or something, where they'd asked for 5 million, and so I didn't promote that. It made the newspaper. Of course, I lost a case to break that streak where I had to admit liability. Uh, I didn't know how I was supposed to win that one, but yeah, there's something like that. Uh, about like your streaks of winning on the plaintiff side.
Well, well, the point is you've had, and there's no arguing about this. You've had a tremendous amount of success defending these cases over the years, and I want you to tell us what you think makes you successful at trial.
Well, no, I hope we know the medicine well. I mean, I hope on our side, like on your side, we try to command the medical issues. We use nurses here a lot. We have a JDMD. We try to get the best experts. We try to be on top on the medicine. But I think young lawyers and certainly plaintiffs' lawyers who are successful will agree, you got to win the jury. And so uh, I've always tried not to do anything to hurt my case with the jury, and not to put myself in a position where the jury would not like my client because they didn't like something I did. So I think trying to win the case in voir dire uh, is very important. Getting off on a good footing with the jury and trying to connect with some jurors, and uh, not doing anything out on too many limbs that would alienate any strong members of the jury uh, who might sway the jury against you. So, other than just making, I hope, an organized presentation and dumbing down the medicine for everybody, but knowing the medicine, I just think connecting to the jury from the start to finish. A little levity here and there, not too much, so that you are making frivolous or trivial, a heartbreaking injury on the plaintiff side, but enough occasionally to cut through the tension of a trial. Just the right balance of that with hopefully, same wavelength of connection to the jurors, uh, and it's sort of like Russell Crowe in the Gladiator movie. You got to win the crowd, and you win your freedom. And so, look, I admire what you've done when these judges have allowed you to use your voir dire technique of going for the first couple of hours and then letting the defense go. I mean, when judges have let you have unfettered access to a jury without the defense speaking for a couple of hours, I've always felt like we're behind. We're behind winning the jury from the start, and that's why when you do that, it's no offense. I object to it because I'd rather be able to talk to the jury a little bit too, and not let you have all the mic time. But I think there's no big mystery to it. I mean, I think you want to be organized. I think you don't want to waste the jury's time. I think you avoid as many fights as you can, and you don't do anything that's going to bring disrespect or a bad ethos for your client in how you conduct yourself. And you never want to lose a case because the jury didn't like you as the lawyer. So because your clients can do a good enough job of that of making the jury mad on both sides.
Sometimes, yeah, that's definitely the truth. One of the things I've seen you do, Paul, that I think is very effective is When I'm having this unfettered access with the jury, you're not just sitting there passively. You're memorizing all their names. So you have this great capacity to stand up in front of the jury for the first time, and all of a sudden you're talking to them by name without having to refer to the jury roster. So it seems like you have more familiarity with them than, and of course, everybody's favorite word is their own name. People love to hear their name, and I think you've included.
There are a couple of, Lloyd, I was the Rush chairman back in the day, so I had to remember names. But if I get enough time, I can memorize 60 names. And, I do think it's nice when you can stand up and say Ms. Jackson, Ms. Thomas, Ms. Williams. But you guys are freezing me out with these paddles with numbers on them, and taking away that little trick. But the only thing you got to worry about, if you mess up one name, that juror is going to hate you forever. So you better know that you've got them all. And so I'm always worried that I'm going to miss one Ms. Williams or Ms. Thomas, and she's going to hate me forever because I didn't really care about her. So now Tony Del Campo, when he was a judge, he would do the same thing. So he may want to rival me on name memorization, but I do think it just shows too you're paying attention, and it shows that hopefully they think, well, that lawyer's pretty sharp. He knows all our names already. So anyway, it is a little trick.
Yeah. Well, let me ask you some harder questions because I talked to a number of my colleagues who were aghast that I was having you on my podcast. They're like, "Well, it's a plaintiff's podcast," and I said, "Well, not really." I said it's a podcast for that focuses on issues of medical malpractice, and I couldn't think of a better guest than to have you on here to talk about your experiences. What are the three biggest mistakes you consistently see plaintiffs' lawyers make in trial?
That's pretty good. Um, one of them, lawyers can't resist the urge to hear themselves talk, and I think overdoing direct examination, and keeping a witness on direct up there for 2 or 3 hours and going over the same things. I mean, that's that's uh, that's one thing. Um, you know, Holding back the cards, maybe something on both sides, something that's not produced in discovery, and suddenly comes up at trial, and that sort of thing. I think that can hurt either side. Uh, but I do think overdoing it sometimes. I like a style that you've got or you've had in the last few trials where you start the examination of an expert with the 3 points you're going to make with them, so that that's signposted for the jury and that's in their heads. Then you come back to them. Then, even if you don't deal on it too much, it's at least in the minds of the jurors the points you're trying to make. You know, uh, you gotta, you got to know how to handle the sympathies and empathies of witnesses. I mean, uh, you can go too hard on a witness. I mean, I've done that myself where I felt like I was too tough on an expert. Uh, you know, some jurors are going to sympathize with these doctors who've been sued, who were just they were in the emergency department, they were just trying to save somebody, and now you're beating up on this poor guy too much. I mean, I think you gotta balance that. But those are some of the things I see.
I think you touched on a hugely important point, which is the credibility of counsel, and it doesn't just, in my view, it doesn't just start in trial. It starts from the very beginning of a case. I mean, are you presenting a case that's been properly vetted by experts, that's been properly researched, where the attorneys have put in the heavy lifting to clearly lay out what the claims are? Because I'm I'm very pro doctor. My father was a doctor. My uncle was a doctor. I'm very pro medical profession, um, but I'm pro good medicine, and I'm very unforgiving personally if I feel like people don't do right by their patients. But the credibility is so important on both sides. If the defense tries to hide something, I'm going to point it out a few times, and I've seen you do the same in court. So that's a really important point. Now I need to be balanced here, Paul. I asked you three mistakes you see plaintiffs' lawyers make. I want you to share with me what the three biggest mistakes are that you consistently see other defense lawyers, not your firm, but co-counsel, because you're almost always in trials with other defense lawyers. What are the three biggest mistakes you see your colleagues make? Won't ask you to name names, but just generally speaking.
Well, one of those would be, again, it kind of goes with that lawyers loving to hear themselves talk. I mean, uh, when there's an expert primarily against my defendant, and I feel like I've got that expert where I want him on cross examination, and then a co-defendant who doesn't really have a dog in the fight with that expert gets up and starts asking a bunch of questions, and they take 30 minutes of time and they kind of muddle what I thought was in a really good position, and the jury forgets maybe the zinger I thought I had left the jury with this expert, and they sit down, and I'm like, why in the hell did you just screw up my expert there? I think too, you know, you get lost in things that don't matter to the jury too much. I mean, an hour examination of an economist, who's simply multiplying average work life expectancy by wage or earnings, and reducing it to present value, to question them for an hour on exchange rates and all kind of other things, I think taxes the jury. I think I honestly, I have a little shtick with experts, and it doesn't take long, and it is what it is. And I've never won or lost a case because of the handling of an expert witness. But otherwise, it's what we were saying before, Lloyd. It's just changing your theory at trial, or uh, not coming clean with document production or medical records. I'll tell you this firm here, when people start at my firm, I tell them we overproduce, not underproduce. So if there's a document that needs to be produced in discovery, we're going to produce it, and let everybody deal with the consequences of it.
Well, that's been my experience dealing with your firm, Paul. Is that uh, y'all will turn over the things you're supposed to, text messages between medical providers, relevant to the care or to the patient. For whatever reason, maybe this is just a coincidence, but it seems that your firm is maybe the only or one of the only firms in town where the professionals ever text each other during the time in question, because we don't see text messages coming out of other firms um, on a consistent basis. I'll just leave it there.
Maybe those defense lawyers are smart enough to tell their doctors to quit texting. But I will tell you, and many of your colleagues know that, when we ask, do you have any texts? And then I get this text that says we should have done that test yesterday, after the patient has died. Um, it's a gotcha moment, and you wonder how in the world are we going to deal with this. But it is what it is. You rack your brain for every possible privilege that might exist, but if there's not one, you produce the document and deal with it.
Right. You can't. I mean, I did defense work a lifetime ago, both criminal defense work when I was in the Army, and then I did med mal defense work briefly with Blassingame Birch out of Athens for about 2 years, and got a taste of it. And I remember Gary Blassingame, who was Mr. Blassingame to me at the time, uh, being very clear that you don't pick your facts. Your job as the advocate is to do the best job you can with your facts, and let the chips fall where they may. But don't get funny trying to hide stuff or be cute with evidence, because it'll come back and bite you, hurt you worse than ever. So, on that point, are there times, and I was thinking of some questions, some interesting things that would be challenging if try to imagine being back on the defense side. But are there times when you get a new client, new file gets delivered to you, you get the medical records, you review the records, and you conclude, yeah, my client really screwed up. He was negligent or she was negligent, and their negligence caused some really bad harm, just like the plaintiff says. Uh, does that ever happen to you? And if it does, how do you deal with it?
It it happens. It happens often enough. I mean, we get cases that have been vetted by your side where you've had an expert look at it and your expert's right. I mean, either we missed a test, we missed a lab, uh, we misread a X-ray, uh, and with or without hindsight bias, it's a glaring, obvious miss. Fail to call somebody back to the office. Uh, you know, when that happens, I mean, I do think, and y'all may not believe it on your side, but most carriers these days, and I think it's going to be even better. I think most carriers these days don't want to waste money on defense costs. Uh, if they're going to be told 2 years later, we can't defend this case. They want to know it now. And I know y'all don't get many pre-suit resolutions. Sometimes that happens. I know it doesn't happen very often, but I do believe you're going to see some carriers who are doing a better job of assessing cases up front. Can we win this? Do we have a chance? What are our, is there a causation defense? Is there a damage mitigation? And let's get this to early resolution. More and more, Lloyd, I do think that carriers are viewing cases that way. In the main, we have great relationships with our insurance clients, but they're mindful of legal costs and fees, and if they're going to have to pay $100,000 to ultimately settle a case, uh, you know, they're gonna look under every rock, and if the damages aren't linked to the standard care violation, then they're going to try to exploit causation. If the damages, uh, are not as great as the plaintiffs is making them out to be, then they're going to try to go that way. But there are cases you have to settle, and we're encouraged, frankly, on this side to tell upper management at most of these carriers if we have a really bad case that needs settling. Because, you told me of a large jury verdict on Friday. I mean, the verdicts are, when the plaintiff gets a verdict these days, in a med mal case, it certainly seems like it's in the 7 and 8 figure range. And so, it only makes sense if you can't make the case better, that people look at the possibility of early resolution.
Well, and I think that just talking to the experts that we work with, um, our experts see a connection between what they're doing on the plaintiff side and patient care. I mean, they realize that they're all pro doctor, they're all pro healthcare system, but the really top notch experts are intolerant of bad medicine, truly bad medicine. And you and I have a case going right now with I think every other defense lawyer in the state of Georgia, and my friend Laura Shamp, and we've got the person who is, I believe, inarguably the world's leading expert in this certain type of interventional procedure to help people with stroke. And and I know I'm not speaking out of turn. I know that he feels very strongly about the cases he gets involved in on the plaintiff side, that there was bad care and an outcome that was avoidable, and sort of takes that personally. So, to your point, I think you're right. I think experts are more willing. I mean, I haven't been doing this quite as long as you, but I know that the better experts on both sides can help the case drive towards a good resolution, or a fair resolution. I want to ask you a couple more hard questions. I know we're coming up on our conclusion of the show, but I want to ask you what trial sticks in your mind as one of your happiest moments? I know anytime you win one, it's going to qualify, and you win a lot and win most. But is there a particular trial where you just felt joyous when the jury came back with the result, or do you feel joyous with every trial?
I can't single one of those out. Uh, we love to win, and I whisper in my doctor's ear before the jury comes back, because I will say, I don't care how old you are, how long you've been doing this, that moment when the jury's about to read the verdict, it causes a vasovagal sensation. But I tell them, no matter how this comes out, we're going to handle this professionally. I've been surprised that we got defense verdicts as fast as we did. I've been disappointed a couple of times, but I can't single one out, because also, I mean, I'm human too, and when we win, the other side loses, and usually there's a personal tragedy on the other side. So, uh, you know, uh, I can't pick one out. I will say, one of the cases I had with you was one of the hardest losses, and I should have known it was not going to be great for me when you had jurors crying in closing argument. But nonetheless, you know, uh, I single that one out as a hard fought case, and a good win for you. And uh, but I can't, Lloyd. There's not one win that sort of stands out. I will say, one of my first cases they trusted me with out in West Georgia, back when you still had to use pay phones and rotary phones. I was on the phone with a claims adjuster at St. Paul back when they did malpractice insurance, to tell them the jury had just retired when they told me the jury was back with a verdict. So one of my colleagues recently got a 15-minute verdict, and I said, "I got you beat. This was like 5." They wanted to go home. So anyway,
That's the biggest nightmare on the plaintiff side, is a quick verdict from the jury after a 2 week or week and a half medical malpractice trial. It is never good on the plaintiff side if you hear the jury has a verdict, within 30 minutes or 45 minutes. That's an ugly feeling. But you brought up the case that we had together, and is it okay if I talk to you a little bit about that case? Because that was the first.
yeah, let's leave the names out to protect the innocent.
Of course, of course, but we had an interesting case involving complex regional pain syndrome was the diagnosis, which is a chronic or a sort of a miserable pain condition that some people can develop, and it was a weird case, the weird mechanism of injury. It was hard to understand. It's hard to explain how he developed this extreme pain condition, um, and that was our first trial I think we had together, and I think you personally kept the verdict down because we got a good result, and I was pleased with it. But I think another defense lawyer involved. I think we could have been uh, a few $1 million higher. But the things that stand out most in my mind about that case, working with you, Paul, was that everything was fluid. I mean, you you were able to adapt. We were throwing things at you. We were using a lot of technology. We were trying to move the ball quickly, and you block us at every step and try to object along the way. And a different jury, different judge. I think there could have been a different result. But the stars did align for us. Thank goodness.
Well, that's nice of you. I do say, in retrospect, I may have lost that case in voir dire. I mean, you, the judge let you do the unfettered voir dire for as long as it took, maybe an hour or two, without us even piping up. You picked a great jury. I mean, you got to, and looking back on it, hardships weren't much hardships, and those jurors got excused. And I'm sitting over there going, "Man, Lloyd's got a bunch of bleeding hearts on this jury. I'm in trouble." And when you had them crying in closing argument, that was Katie bar the door. And when the judge let them examine the jurors come out of the jury box to feel your client's arm for temperature changes, it might have been. I was a little surprised by that, but you were very savvy to come up with that notion, and you know, uh, it turned out well for you.
We had a legitimate. Well, just for our listeners context, we had there's a real debate what my guy's condition was and whether he had this pain condition. And one of the signs that might suggest he had it was a temperature difference in one hand versus the other hand. And I had my expert touch my client's hands in trial, and he said, "Yeah, I guess one hand's colder than the other. That's consistent with this pain condition." And then you brought in this Hollywood expert out of Rhode Island who was 6'4", looked like he just skied in off the mountain from the U.S. Olympic trials, and Hollywood guy. I mean, he'd make Robert Redford ashamed of his looks. And so I took a chance. I think, after giving it a little bit of thought, I took a chance and said, well, I think I'll have this guy touch my guy's hands and see if he'll acknowledge there's a temperature difference. So we had him touch my client's hands, and he touched them. And predictably, the defense expert's like, I can't tell if there's a temperature difference. So that's when I turned to the judge and said, well, Judge, I think the jury should be allowed to examine the evidence themselves, the hands. They could tell temperature difference. They do it with their children anytime they have a fever. You see if they have kids a little bit hot on the forehead. And and I don't think I caused an aneurysm, Paul, but I don't think you were very accepting of my efforts, and you objected a few times, then a few more, and we had a rigorous debate with the judge. And the judge finally said, I'm going to let the jury do it. And I was all happy with myself because I had won this big debate. And then I turned to the jury, and nobody wanted to touch my client's hands at first. And I was like, look, I was pleading with my eyes. I was like, look, we just won this motion. And then finally, this one juror, I can still picture him, said, well, I like to touch his hands. And then my client walked over. He's a tough kid from, up north, working class kind of guy. He puts his hands out, and the first juror touches his hands, and then the second juror, then the third juror, and almost the entire panel touched my guy's hands with like this gentleness. And that's where I think we won the case. I think the jury put him over the edge after that. Well, and when it was over, you came over and shook my client's hand. You shook my hand. You congratulated my client. You and your whole team were the absolute professionals. And I know that was nobody likes to lose a verdict, and that was a good result from our point of view. And I appreciated that, and I think that has kind of informed our relationship since. You've always you never make it easy. I'll say that. You throw elbows. I'll say that too. But you're the consummate professional, and I appreciate opportunity to work with you.
Thank you, Lloyd.
You bet, Paul. And I appreciate you being on the show today. And thank you for taking time out of your busy schedule. I know you're the busiest defense lawyer in the state, and if you didn't have this trial that had gotten continued, you wouldn't be available to us. So I'm grateful you made time for us, and look forward to seeing you in the courtroom soon, if not sooner.
Hey, thank you, Lloyd. We'll see you soon.
Thank you, Paul. Take care.